Welcome. My name is John Broome. I'm the Deputy Chair of the Contracts and Procurement SIG. Our mission as a SIG ranges from spreading the basics, because we believe almost every project manager should have basic competence in contract and knowledge in contracts and procurement, to the advanced stuff and the thought leadership. Today, we're more about covering the basics. So this webinar is inspired by two quotes from Warren Buffett, who's the world's greatest investor. And his one quote says, "It's easier to stay out of trouble than get out of trouble." And as a result of that, and related to our field, it's impossible to unsign a contract. So do all your thinking before you sign, which is very, very good sage advice. And as a contracts and procurement person, too often clients are willing to spend a hell of a lot of money trying to resolve a dispute and all the problems. And if they just spent a little bit more thought early on, they could have avoided it. If this is the first of 3 webinars, it is titled Contracts. What are they all about then? I'll leave Sarah to cover what you're going to cover. In terms of Sarah Schutte, I've known probably getting on for 5 years. I've worked with her. She's a qualified lawyer, etc. She's a good communicator and she's very practicable. Having worked alongside her, she gives good practical advice. She does not, like me, she does not believe that project managers should become lawyers, but they do need knowledge to avoid what our chair, John Lake, refers to as gotchas. They do need to know when to seek further advice. And with that, I will hand over to Sarah. Take over.
Thank you very much, John. Welcome everybody to this webinar. I am absolutely thrilled to be here, and I'm grateful for APM, to John and to Maya for everything they've done to make this happen. It's wonderful to see so many people having registered and signed in, not just registered, but also signed in this afternoon. So I hope that this is going to be very topical, very useful for you, and with the new year having begun, give you something to take away this afternoon and go straight back to your desks and apply to your day jobs and what you're doing. So welcome to that. Basic contract law for project managers. This is the first webinar of 3. And as John said, it's entitled Contracts, What Are They All About? The topics we're going to cover today in this 1-hour session are contract formation and the 5 key components of contracts. We're going to look at letters of intent. We are also going to look at express and implied terms. I'm going to talk a little bit also about freedom of contract and the boundaries and the legal framework in which contracts are formed and are executed, because I think that's of use to project managers. And then finally, I'm going to say a few words on special contracts, which we find across the project management industry. In total, as John mentioned, you are able to claim 1 hour of CPD points. So as background to the series, as John says, I'm a lawyer in the construction and engineering industry primarily, and I've been running a small consultancy, independent consultancy, for the past 4 years. Prior to that, I spent 10 years as a senior in-house lawyer, and prior to that, I was in private practice for 6 years. Now, I mention those just to give you an idea of the breadth and the background to the work that I and my organisation do. And what we believe very strongly is that law has to be used in practice. We have to apply it to your projects. We have to use it with the reality of business operations. And as your project develops and delivers its outputs, to use your proper project manager terminology, we're talking about benefits realizations, achieving the things which the projects are setting out to try to achieve, then law is central to that. Project managers are central to that too, and you are there to ensure the smooth running and smooth delivery of your projects. And you'll know from your jobs that you have a number of things to juggle, that you feel you need to be multi-skilled in a number of areas. That's not to say that you're meant to be an expert in all of these areas. You're not going to be a lawyer, a planner, a programmer, a risk manager, an insurance manager, but you need to know enough about each of those disciplines to be able to take advice from people who are experts in those areas to be able to feed into their reporting, to be able to use their data and the like. So you do have a lot of areas in which you need to have some knowledge. Now, parties to a project, of course, depend on you. They depend on project managers to administer, to manage the project, and in some circumstances to give directions to the parties as to how they should proceed. So on the back of that, and given those circumstances, why should you learn about contracts? Well, from my perspective and in my experience, there are two main risks. The first is that the project is at risk. Now, when I say that, I don't necessarily mean a catastrophic risk. What I mean is that delivery is suboptimal, or it doesn't quite achieve the benefits which it has set out to achieve, or there is general satisfaction about how long it's taken, or the quality of the work, or the money that's had to be spent. And that, of course, then potentially impacts on you and on your organisation. So there's a risk factor there as well. With that in mind, definitely get yourselves the basics, and that's what we're going to try to achieve in this webinar series. But also, and it's very important to know this, do know your limitations. You're not an expert in every area, and there are people on hand who can help you. So, this webinar specifically, let's drill down into what we're doing here. The foundations for today are that we deal with contracts every day as project managers, but what actually is a contract? We also have relationships, and those relationships look like contracts, but they may not in fact be contracts. We are also asked to work with people and other organisations, and therefore there's some sort of arrangement. Now, that arrangement may or may not be a contract. Whatever the situation across that spectrum of relationships, projects are at risk where that relationship is unclear, where the terms of the relationship are poorly drafted, where there are misunderstandings between people, or simply different interpretations of what should and shouldn't be happening. What that means is that projects are at risk, and by risk I mean fragility. I mean there is a vulnerability in that relation and for that project as to the money that needs to be spent, the time which is required to achieve the outputs, perhaps issues about quality, and certainly reputational risk. So understanding the basics of contract and how those apply is most certainly an essential part of your risk management as a project manager. And I hope you will feel it will enable you to do your job better when you do have a little more knowledge about the basics of contracts. So let's start that journey and get stuck right into contract formation. In order to have a contract, there need to be 5 key components. We need to have an unequivocal offer, an unequivocal acceptance of that offer. We need something called consideration. We need something called intention to create legal relations. And we need something called capacity. Now, without any one of these, we in fact have no contract in law. The risk of not having a contract in law is that we have uncertainty. We don't want to have relations in projects that are based on uncertainty, that someone else, and this will be the Court of England and Wales, in this jurisdiction, the court will decide the terms of that relation if push comes to shove and the parties can't agree themselves. For example, if it's unclear what fees should be paid to a consultant on a project, the court will decide what those fees are. They will use something called, as a legal device, called a quantum meruit, and it means what is deserved. That's the translation from the Latin. We now think of it as what is reasonable to pay in all the circumstances. Now, if you think about how that could apply to your projects, you need to have cost certainty, don't you, of those contracts which you are managing and the payment terms which you are administering. If there is uncertainty and risk in relation to the terms of an engagement, that potentially puts project budgets at risk. It makes it difficult to report to stakeholders, and it makes the project look as if it's not very well managed. So I want to look at each of these 5 things in turn now and try to button down some of that uncertainty for you to make sure that you have all 5 elements to create a properly legally binding contract. So let's look at offer first. A legal offer, to be an offer in law, must be very clear as to its terms. And correspondingly, it must thereafter be clearly accepted in order to create an agreement. Now, with offer, what we need to do is to make sure that we actually have a true offer. We might have something that looks like an offer, but is in fact known in legal terminology as an invitation to treat. An invitation to treat is in fact, in legal terms, not an offer, but it is an invitation to enter into negotiations. It is something which precedes a legal offer being made. For example, advertisements, requests for proposals, tenders, etc. Those are all invitations to treat. They are not legal offers. We need to have an offer after the invitation to treat in order to have that first of those 5 elements. So, bit of practical recommendation here is to just take care at those very early stages of your projects to think about whether you do in fact have offers on the table or in fact you have invitations to treat. If you're clear that you do have an offer, that offer is then capable of acceptance. An offer is only accepted in legal terms if that acceptance is clear and if we understand the terms on which the offer is made. So that's the question for you. On what terms is the offer made? Now, quite commonly, we have a situation in projects, especially with email correspondence, something which in legal terms is called battle of the forms. It sounds quite exciting. It's actually usually extremely difficult and challenging to work out. Battle of the forms relates to a situation where you have a to and a fro of terms and conditions being exchanged between parties, proposed parties to a contract. Commonly you find those attached to emails, or you see a footer in an email saying everything we do is subject to our terms and conditions, click here for a copy, something like that. But whose terms and conditions actually apply when it comes to the crunch of acceptance? That's a really difficult thing, and the court has tackled that consistently over several years. We might have part acceptance of terms, and that's another difficult area to think about, where some terms have been accepted clearly, but others have not. Do we have a contract or not? Do we have a contract on certain terms and not on others? Well, as I said, the court's been very consistent over a number of years. The judges are trying to see a very sensible, pragmatic way through, and that accords entirely with the way in which my business is run here. We're trying to find a sensible way through and find that contract. And that is because we realize in that situation that in fact the parties want to be engaged with each other. They want to have a relation to enable whatever the services and works are being offered and accepted to actually happen. So the court will try to find a contract if it can, but it won't be able to stretch the meanings of things or to get through that battle of the forms without some very difficult digging and forensic application of which parties T's and C's apply. So there's quite a number of difficulties at acceptance stage. My very practical advice to you is just to take care at those early stages again, to try to map out what the obligations are on each side. And that's especially the case when you have multiple offers on the table. If you're looking at different tender returns, for example, you're trying to find where does acceptance actually occur. One device which might be useful to you if you're client side project managers is to try to ensure that your clients' terms and conditions apply. You can do that by using the methodology which I already explained about attaching it to emails, attaching it to every piece of correspondence. You can also use the phraseology of subject to contract Now, of course, be careful about using phraseology if you're not really confident about what it might mean. But in essence, you can use it to try to avoid the kind of risks with the acceptance criteria and to prevent an agreement being made until the contract terms come together. So that is quite a useful way to avoid inadvertently getting into contract with another party. So we have an offer on the table, the offer has been accepted, and then we need the third element, which is consideration. Consideration is a legal term. Consideration means money or money's worth. Money's worth being something which has financial value but is not cash. Money or money's worth paid by one party in return for the provision of services or works by another party. That's your general, that's the general thing which you're going to be looking for to make sure that you have consideration. I've put together a little bit of a checklist for you, which I hope will help to try to make sure that you consider all the different parts of consideration that you need. The first one is to make sure that it's very clear what the payment mechanism is. So you understand, and everybody understands, the basis on which sums due are going to be calculated. Okay, so it comes back to that fees example I gave you earlier. In conjunction with that, we need a payment procedure. So what the timing and methodology is for making payment and applying for payment. Whether there are any conditions which attach to the payment mechanism and procedure. For example, is it a requirement that before the first payment, a certain number of collateral warranties or a performance bond or a parent company guarantee need to be provided and executed as signed? Is there any documentation which needs to be included with the payment application to prove that costs have been incurred? Have a think about as well which standard form of contract, if any, and it will depend on the industry to which you belong, if there are any standard forms which apply to your contract or form the basis of your contract, and whether those have been amended in any way. If you're a project manager in the construction and engineering sector, you must make sure that the consideration part of the contract is compliant with the Housing Grants, Construction and Regeneration Act as amended. Do remember that certain construction and engineering works and operations are not subject to the Act, so do take care with that part of the contract. And if you're in the public sector, you might find that you need to take special care, you will find that you need to take special care with the Fair Payment Code. So lots of different things to think of in consideration, not just as simple as saying, we will pay you X for Y. Right, project managers need to also take care that they're going to then flow down that consideration criterion to the supply chain as it's appropriate, okay, and do take care also with the regulatory part of it. So if we're happy with consideration, we need to now bind ourselves in contract with another party. So we're looking at intention to create legal relations. Now, I have to say, it's not usually a problem in commercial projects. We don't usually get to a situation where we're questioning whether somebody actually intended to enter into a contract or not. But looking at it from the other way is we want to create a contract where we have absolute certainty. So we're avoiding these potential risks that we don't have a contract. So what you need to do to satisfy this limb of contracts is to include in your contracts a statement of the reasons why the parties have come together to deliver their project. Okay. Again, I've put together a little checklist for you, which I hope will be helpful. That statement of reasons needs to include the following three elements. First of all, it needs to include a description, a background of what the project is. Legal terminology is known as recitals. So this project is about a piece of land at X address on which it is intended to build something which is described in the employer's requirements, that sort of thing. The second element that you need here is to make sure that it's clearly set out what each party is going to bring to the project. I've given you a couple of examples here on the screen. X owns the land and wishes to build a 100-meter tall skyscraper. So it's very clear what X's role is. They're the landowner and they have an intention, a desire to build a building of particular height. And we have Y, who is an experienced skyscraper constructor. So again, it's very clear what Y is bringing to the project. It's bringing the skills and the knowledge which is needed in order to build a skyscraper of the requirement of the employer. Okay. And the third thing that you need to include is a joint statement. The joint statement will be actually the part which satisfies the intention bit. So you can use the words which are in speech marks there, a statement of both parties with an agreement to enter into this project. So X and Y together agree to enter into this contract. It is relatively straightforward, but you do need to take care to include those things and make sure you properly scope out what the recitals are and what each party is bringing to the project. Okay, that's the fourth thing. The fifth thing is capacity. Similarly to intention to create legal relations, it's not usually a problem in commercial projects, but there are a couple of things that you need to take care of and not assume as given. Capacity refers to the ability, a legal ability to enter into a contract. It's usually only an issue in personal contracts where we're talking about mental wellness of individual people. In relation to the mental wellness, if you like, of an organisation, what we need to do is to make sure that we have signatories to the contracts who actually have the authority. They have the right to bind the organisation. So as project managers, you need to make sure that you have an authorised human on behalf of the non-human organisation, to put it in very simple terms. What I found very useful when I was an in-house lawyer was to obtain a confirmation from the party, the other opposing party, prior to execution as to who would be the signatory and what capacity they had, possibly even a copy of the authorised attorney. Because you want to make sure in organisations where there are changes in executive teams, where you do tend to find changes in the authority element, who are authorised attorneys. We had a list at one of the in-house positions I had, and that changed, I think, every 6 to 9 months or so. Okay, so you need to make sure that you are certain about who is signing the contract on each party's behalf in order to satisfy that fifth element of the contract. Right, so having talked about contracts and sorted that all out, let's have a look at letters of intent. Letters of intent is something which I'm sure many of you have come across before. Why might we use a letter of intent and not a contract, having spent lots of time talking about contracts? Well, I have to say they're an extremely useful device. They do enable works and services to start quickly. We don't have to wait for the to and the fro of what can sometimes be protracted contract negotiations. In other words, we don't have to wait for the contract to be formed. We can use this sort of shortcut to get works and services starting quickly. What you need to do with letters of intent is to make sure that you have a statement in the letter that you do plan to enter into a contract later on. The risk that is associated with letters of intent and where they usually come a cropper for project managers is that the contract is never actually entered into. And in conjunction with that, you have an expired letter of intent. And in conjunction with that, you have work still and services still continuing. So you've got the sort of triple whammy of risk associated with this letter of intent. So my very practical advice to you is to be really careful. Do use them. I think they have a very good and useful purpose, but do be very careful to state clearly that they have a limitation on time. So set an expiry date. Have a look at termination criteria. Can anybody terminate at any given point? Have a limitation set as to how sums are going to be spent, or what the authority to spend money is, and the recompense which will come accordingly. And then thirdly, think about specifying the terms on which the letter of intent is made. Lots of the time I do see a reference to the planned form of contract. So this letter of intent is based on JCT or NEC or FIDIC or whatever, and when we enter into contract, we intend to do it on the basis of that very same contract, something of that nature. So takeaway, letter of intent, very, very useful, but project managers do keep an eye on things, and it will be part of your duty to do this. Don't let things drift such that we get into that triple whammy risk scenario. Let's look now at express and implied terms. So terms of contract are what we think of as the clauses of contract or the provisions, usually numbered. There's a number of different types of terms. We're not going to spend a lot of time on those today, but I need you to just be aware that there are different types of terms, lots of different legal names. We have conditions, we have warranties, and I've put there not a collateral warranty. That's an entirely different beast. A contractual warranty is a type of term. We have conditions precedent, we have undertakings, and there are in fact a few more as well. So do be careful about terms. Each of those different types of terms has a different legal impact, and this is an area where I'm going to unashamedly say you will need to take advice on different terms of contracts. In general, though, any terms can be express or implied. Express terms are those which are stated in the contract, and implied terms are those which are not stated in the contract. So you can pretty easily work out what your express terms are. The risk, of course, is what you can't see, and that's the implied terms which are not stated in the contract. Implied terms can be a bit of a fiend because a lot of them are negative. For example, don't break the law. That's an implied term. You don't need to tell somebody in a contract not to break the law because that is an underlying part of the law. Most implied terms are negative, but they can also be positive. Here's an example, a good example actually, and a very real example of an implied term which is a positive one. The employer is to allow the contractor a reasonable time to fix a defect before it can call a third party and spend the retention. Now you probably don't want that as an implied term in your contract because it brings uncertainty with it, doesn't it? Reasonable time, what could that be? Well, it depends on all the circumstances. But as project manager, if you're managing that project, you don't want to give someone a reasonable time. You need to be able to put it in the plan, to get the planner to put it in the plan, and to make sure that it's fixed by X date. If it isn't, then you know what you need to do in terms of spending the retention and calling third parties to assist you in those repairs. So implied terms, very difficult. Try to not rely on them unless you're absolutely sure of their impact. The difficulty with implied terms is we don't really know what their impact is because they have this concept of reasonableness. Good example there, following on from the previous example, a reasonable time to finish the work given all the circumstances. Compare that with an express term which will say a completion date of X. So you can see how express terms are much more useful and give you that certainty as project manager than implied terms. Now, you might want to rely on implied terms because you might think it's more favourable to you to do that. That could work, but that could be a gamble that doesn't pay off because you may not know exactly what the outcome of that implied or which implied term you got until the dispute arises. So don't gamble on that is my advice. Thus, minimise the use of implied terms. I would say also I'm a big advocate of not making contracts lengthy and too onerous on trying to capture every single implied term which might ever exist. So it's a balancing act to get what's sensible for your project in the circumstances. Just be aware of implied terms. Let's look a little bit now at legal frameworks and contractual frameworks. Looking first at the legal framework. The legal framework is all about the law which applies in every jurisdiction. And if anybody's heard me speak at conferences or on any other sorts of training, I always refer to law as being a straitjacket under which project managers have to blend the art and the science of their discipline to satisfy. So law sets out a framework for behaviour, it prescribes rules, for individuals and organisations to operate lawfully. In other words, without any criminal or civil consequence. Bringing it right home for APM project managers, it underpins your certification. It should give you comfort to have faith in the authority of the APM as a business, to uphold professional and ethical standards. Okay, that's part of the legal framework. A legal framework will also mandate boundaries for dealings in what is otherwise a free market. By dealings, I mean contracts and I mean terms of contracts. So within the legal framework, we have those boundaries that set the basis for the dealings which we have, organisations to organisations, consumers to consumers, and a mixture of the two. So all sorts of dealings. Now, if we hone in a little bit on the legal framework, I want to show you how complicated the UK legal framework actually is. And I'm going to put all of these up on the screen straight away. You'll see that I've highlighted a number of points. We have lots of different ideas that contribute to the legal framework in the UK. And we start with the common law of contract and tort, and we supplement that in a number of ways. Law is supplemented primarily by codification. That's your statute and your regulations. I put a handful of examples up there. Some of you may have come across one or more of those pieces of legislation at any particular time. Try to pick pieces of statute which apply across the board. There is a supplementation of the common law by regulation too. So we have lots of regulatory bodies. We also have a number of pieces of compliance, which is a mixture of legislation and also compliance bodies. There is also the dimension of European law, and that is not likely to change as far as my understanding goes following Brexit. So EU law will continue to apply more or less as it's been made already. And then on top of that, we have industry-specific codes of practice. So whichever industry you operate in, there'll be codes of practice which apply to your sector. And then finally, we have common law not being supplemented, but being bolstered, being cushioned and being supported by case law. Case law is judgments of the court and decisions by other bodies, commonly known as tribunals, which have devolved jurisdiction. So they have the court jurisdiction devolved to a specific expert tribunal. You can see there that it's a pretty complicated legal framework that we have in the UK, and it does change frequently. We have case law coming out all the time, lots of new rules, regulations and compliance stuff at the moment as well. So do get up-to-date advice on any aspect that you need to be dealing with. So after the legal framework, or rather under the legal framework, we have contractual framework. And in the UK, we have freedom of contract within the boundaries set by the legal framework. And that is the nub of project dealings. In terms of your role as project managers and any contracting strategy under a contracting framework you might get involved in, and I would encourage you to try and get involved in if you can, I've put together a short list of things you might like to consider. So first one is, what's the driver for the project and why? Why are we doing what is being proposed to be done? It's a really good question to ask, because quite often it's not terribly well thought about and not terribly well mapped out. So it's an opportunity for project managers to add value here to their clients. Contracting strategy does depend rather on the importance of strong and effective leadership, sometimes called project sponsoring. Another area in which project managers can have impact in contracting strategy is in relation to those who are outside of the project directly, but who have an interest and a legal interest in the project. So what kind of impact funders might have, stakeholders and any governance function. I would also encourage you to look at how delivery and output obligations can be flowed down. Is there any need to do that? Is it desirous in some way? And is it even possible? These are all good questions which project managers can look at with their clients. And do also make sure that you have a look with a risk manager at the interrelation between the enterprise risk management and the project risk. So what is the corporate stance on particular types of risk, and how does that flow down into the projects? Finally, do take care to take note of quality assurance and standards to make sure those are included in the contracting strategy. Okay, there might be some from the organisation itself, or they might be more generally available from the industry sector. So takeaways for today. It's really something for you to think about, and I always encourage project managers who come on my workshops to think about these questions as well. What can you as a project manager bring to that conversation about contracting strategy, proposed projects? Have a think about it now, and also then take it away this afternoon. I'd be interested to hear from anyone who has ideas on what they would like to bring to conversations and the kind of challenges that they're experiencing in having that visibility. The risk, of course, is that we have non-compliance with legal frameworks and or contractual frameworks. So in terms of the contract, your contract might be judged unfair and then it comes to an end. It no longer exists in law. Slightly less catastrophic, but slightly less difficult is the second one, which is that the contract term is struck out as being unfair. Okay, and that court will imply a fair term to take its place. So there is something in the contract which is legally unfair. That term will be pulled out of the contract, and in its place will be put a fair term. Now, that's not a term which is contractually negotiated. That is a reasonable term as sits between the parties. That's not a risk allocation issue, and it's not a strength of negotiation issue. So be careful of those two. The third one, do remember statutory terms take effect automatically. If you're in the construction arena, you will hopefully know about the scheme for construction contracts and adjudication, and also the automatic application of certain payment terms of the Act. Okay. Another big risk, we've seen this repeatedly in the public sector, is that procurement has to be repeated. So if there's some procedural failing, which means that the legal framework and the contractual framework are not compliant, then that exercise has to be redone, and that is of course at huge cost. Other potential liabilities are civil and criminal liabilities and personal stripping of accreditations, depending on your discipline and your sector, but not a great place to be. So we want to avoid risks of non-compliance. My advice to you, do include special clauses in your contracts which guard against that unfairness potential, and also include a clause which is going to enable the rest of the contract to continue even if a particular term is struck out. You'll need to take advice in relation to the drafting of those parts of the contract, but it's great that you just can be aware of what you need to do to guard against those risks. Let's look briefly at special contracts, because they do deserve a little bit of airtime of their own. So not all contracts are the same. Very important to remember, English law does not in fact recognise the concept of good faith. There are a number of other jurisdictions around the world which do, but English law does not. That is not to say that you're entitled to act in bad faith. One is not the opposite of the other. You're not entitled to act in bad faith or be dishonest or be reckless in any way, but that doesn't mean to say that there is a positive obligation to act in good faith. Okay, that doesn't exist. Having said that, there are moves within the courts to give weight to clauses which are asking for the parties to behave contractually cooperatively, and also to give weight to what I call purposeful contracting. And I put there, it's to be welcomed, in my opinion. I think the court is going quite a long way now towards giving quite practical solutions to parties who are trying to be in contract with each other. And if you have clauses in contracts which ask for particular types of behaviour, then the court will try to give effect to them as far as they can. So here's a few special contracts that you could usefully look out for in your projects. They will depend, of course, on the industry sector to which you belong. Construction contracts are special. They are contracts which allude to the requirements and the minimum standards of the Housing Grants Construction Regeneration Act. I've put in square brackets there the NEC form of contract. The NEC form of contract is not a special contract as such. However, it is one of those contracts which is wanting the courts to give weight to a particular clause demanding that cooperative behaviour. There's a reference there to the clause 10 and the words of the contract, mutual trust and cooperation. That's what the contract demands right up front in the first clause of the contract. So it's in square brackets to flag it up to you, but don't consider it of itself one of these special types of contract. Moving on, in the insurance arena, you can only have an insurance contract if you have good faith. So good faith in disclosure, for example, you must be honest about the presentation of risk which you're making to the underwriters who are going to insure your property or yourself or your project in return. Partnerships, trusts and fiduciary contracts, those are all a different sort of a contract. And in order to be in law one of those types of contracts, you must have in the contract a good faith requirement. And again, if it's not there expressed, it will be implied in any event. So anything to do with proper trusts and partnerships, multi-party contracts, to use the NEC term, and any sort of fiduciary contract, you have that good faith requirement. So do be aware in the projects that you work in that you might have special sorts of contracts. Let's have a look now to summarise where we've got to today, and then we've got, I think, about 10 minutes or so for questions. So not all contracts are the same. Do think about whether you have a contract, or in fact you have a letter of intent, or in fact you have something else, some other sort of relationship. Does your contract do what you need it to do? Yeah? If it doesn't and you're having challenges with it, what can you do about it? We're actually going to tackle some of those that last bullet point in webinar 2, which is coming up in March, called Building a Contract. We're going to look at particular building blocks of contracts and dive deep into different sorts of terms of a contract. So if that appeals to you, if that's what you're involved in your job, do join us for webinar 2, Building a Contract. Thereafter, in April, we'll have webinar 3, which is what to do when things go wrong or the unexpected happens. And that's really going to pull together everything we're going to be doing in webinar 2 and what we've talked about today, all the different sorts of risks and what your options are, and how as project managers you can go about managing out the problems which are being experienced. So as I wrap up this one and questions are coming in, I would say do join us for those 2 webinars if you're able to. Please do give us feedback in the meantime. I would very much welcome your thoughts on today so that I can feed those into the next 2 webinars. I'm very happy to take any questions which have come in or answer in any more depth some of the points that I've made in the last 50 minutes. And if anybody would like to get in contact or they would like to talk about anything further offline, do get in touch through any of those mediums, modern, old-fashioned, and everything in between. Thank you all very much for having me. If there are questions to answer, I believe those are going to be fed through to me right now.
Thanks very much for that, first of all. We had a few moments ago about 10 questions to give, and they spread throughout the seminar, so I'll by and large go from the top. Some of them are probably fairly quickly answered. So if someone with capacity signs a contract and then later leaves the business, does the contract need to be re-signed for legal reasons?
No, it doesn't. It still stands because at the time it was executed, it was valid.
Okay, thank you. Now, question number 2, from Joanne. If you add express terms, does this override the implied terms?
Yes, unless they are incompatible with any other legal rule.
Do you just want to give a flavour of that, what that legal rule?
The example in the slide was quite a good one, where the implied term in law is that a contractor has a reasonable time to finish a piece of work, given all the circumstances that affect that piece of work. Compare that with an express term where you say the contractor needs to complete the work by X date. In the absence of a term that says this is the date you have to finish, you'll be given a reasonable time. And of course, that's anybody's guess. So that's the risk with your implied term.
And this is a comment, but with a question mark at the end. I thought uncertainty was always in favour of the contractor.
Well, it certainly won't feel like a joke when you're in the middle of trying to deal with it. I can assure you of that. No, uncertainty is not always to the contractor. The court will look at the bargaining power of the parties, which I think is where this question is probably going, and it will look at the relative strength of the parties to that bargain. The very obvious example you have is that where you have a very small trade getting into contract with a very large main or tier one contractor, having terms forced upon it and having to sign them in order to get the piece of work and get the fees in. Now, there is a very big risk for that main contractor, in my experience, that some of the stuff which it is forcing on that small contractor may well be what the law would then say is unfair in those circumstances. And in those circumstances, the benefit would be given to the smaller contractor, and that term would, in all likelihood, be struck out, and a fair term would be put in its place. Now, I think that's the way in which that would work, but there's definitely no automatic rule. The court will look at all the circumstances, and again, that in itself is a risk which you want to try to avoid.
If a letter of intent is agreed on the basis of a standard form of contract, can the contract agreed be amended from its standard form, or must it always then be a standard form of contract without any project-specific amendments?
No, the short answer to that is you can do what you like, provided you adhere to the underlying legal framework and the contractual framework of the standard form. You can change the standard form as much as you like, as long as it's made clear in the letter of intent and then flowed through into the contract after letters of intent, which are very short and which just say this is on the basis of the standard form. And I have seen others which have a great big stack of clauses behind them, which are all the amendments to the standard form. So something which could be as short as 2, 3, 4 pages, letter of intent, suddenly turns into, you know, several dozen or even more than 100.
Thank you. Next one comes from someone presumably in Scotland. It says, is there a significant difference between the nature of a contract stroke the 5 essential components under Scottish law than those covered in the webinar?
That's a very good question. The short answer to that is no, there are no significant differences. The underlying Scots law, and this also applies to Northern Irish law as well, so all 4 parts of the UK but 3 jurisdictions. England and Wales has 1 jurisdiction, the Scots and then Northern Irish as well. So no, the contracts in all 3 of those are based on the same premise and the same 5 aspects. Scots law does have some slightly different terminology, and if that person who asked the question wants to pick up on that separately, I'd be very, very happy to try and help match up parts if that would be useful. But in essence, no, you form contracts on the same basis all over the UK.
Okay, and although this is from Suzanne, does Scottish law recognise good faith?
The court system has dealt with good faith in more or less exactly the same way as the English court has, so no difference there at all.
You might have to answer this question in generality from Ashkan. It's what parts, bracket schedules, of a government project have more weight from a project management point of view? What
have more weight? What's of more interest to a project manager? Well, I hate to say it, but I think as someone who frequently works with ANATs for project managers in government contracts, you're going to have to read the whole thing, and you're going to have to probably also divvy it up to people who are subject matter experts, because you're going to have some very technical stuff to look at, which is beyond your and also my beyond all of our expertise. So it's really about picking a really good team to work with and making sure that everybody can cover off all the different parts of the schedules. They are pretty hefty. They're certainly something that you need to tackle with a good breakfast and a cup of coffee inside, I would say that.
Right, okay. I'll probably come back to another one. What would be an example of an unfair contract term or clause?
Oh my goodness, there have been lots and lots of unfair terms and clauses. You could, to go back to the small contractor, big contractor question, you could have a very unfair term which said that the small contractor had to wait a really unreasonable amount of time before it could be paid. Now, of course, that is all over the media at the moment, and it's never really something which is out of the media. But if you're talking about an outrageously long term of, I don't know, 300 days or something like that, that is most definitely an unfair term in a contract where you've got a small trade supplying something relatively small, relatively ring fenced. They're on site, they do the job, they're off site, and they have to wait 300 days to be paid. I mean, that's a very easy example to give in a way. More difficult, and this is maybe slightly extending that line of thought, more difficult is a term which almost teeters on the edge of being unfair. So a term where a supplier in that situation has to wait, let's say, 120 days or 150 days or 95 or something of that nature. Now, we've all been in contracts where we've had to wait 90 days, and it's interminable. To work 1 month, get to the end of that month, then invoice it, then wait another 90 days. I'm not sure that the court is going to say that is of itself unfair unless there are very particular circumstances which apply to it. But it's an uncomfortable place to be, and there are all sorts of discussions we can have about fair payment and how the industry operates and all that sort of thing, which we're not going to do today, but I'm happy to do with anybody who wants to do it. But unfair terms can sometimes be very, very easy to spot, and other times they can just make you feel uncomfortable. And if you're in a situation where you're reading a term and you think, oh, that's a bit harsh on someone, that's your warning bell. That's the alarm in your head to say, could this term be unfair? What are the chances of this term being complained about? Because you have to make a complaint. The court won't get involved just of its own volition. You know, per se, parties to a contract are parties to a contract. It's if somebody complains about it, says, you know what, this is actually really unfair. This is so disproportionately burdensome to me that I'm going to make an application to the court and I'm going to ask for it to be struck out. Now, that's a place that nobody wants to get to. So if you read proposed contracts and you get a really bad gut feel that something is just really not fair, it's not about people who negotiate badly. If you make a bad bargain, the court's going to say that's tough. But if you make a bargain which is actually a very unfair one, then that's a different kettle of fish altogether.
Okay. I'm afraid lots more questions have come in, but we're going to have to run out of time. Attempt to try and get back to you and answer them briefly, and Sarah will see a copy of these and perhaps possibly include some of them in the future seminar.
Yeah, I will. Thank you, John.
Yeah. So I'll finish off with a big thank you to Sarah for doing this. Thank the people who've already given feedback as questions for saying a very useful, interesting seminar. The next seminar is on the 6th of March at the same time. I hope most of you, or all of you, can join us then, and it's at 12:30 p.m. And with that, I'm going to sign off.